Welcome to International Trade Minute, Quick Fire Trade News, the essential podcast for today's trade professionals, presented to you by Rydell Law Firm. If you're a seasoned practitioner, this is where you'll find your weekly distilled briefing on the pulse of international commerce and regulation. We bring you the latest legal and trade news, distilled into straightforward, bite-sized updates for busy trade professionals. Sponsored by Rydell Law Firm, this podcast is crafted by expert trade attorneys to keep you ahead of the curve with concise, actionable insights. Perfect for your morning commute or coffee break. Stay informed without the fluff. Subscribe now on Apple Podcasts and Spotify and join our professional community on LinkedIn. Today, we're exploring significant developments in international trade, including Chinese sanctions on a major U.S. drone manufacturer, important CIT rulings, new Treasury outbound investment regulations, ITAR defense services changes, and updates to customs broker education requirements. Let's get started. First up, in a significant development that underscores the growing tensions in U.S.-China trade relations, Skydio, America's largest drone manufacturer, is facing a severe supply chain crisis following Beijing's imposition of sanctions. The company, which supplies crucial drone technology to Ukraine's military, has been cut off from essential Chinese components, including critical battery supplies from its sole provider. The situation has escalated to the highest levels of government, with Skydio's CEO, Adam Bry, meeting with U.S. Deputy Secretary of State Kurt Campbell and engaging in discussions with senior White House officials. This crisis represents more than just a commercial dispute. It's being viewed as a strategic move by China to potentially eliminate a leading American drone company and increase global dependence on Chinese drone suppliers. The timing of these sanctions is particularly challenging, as Skydio had not yet secured alternative suppliers when Beijing implemented the restrictions. Chinese authorities have directly intervened, visiting Skydio's suppliers, including Dongguan Power Amp, and ordering an immediate severance of business ties. As a result, Skydio has been forced to ration battery supplies for its drones and doesn't anticipate new supply solutions until spring. For trade practitioners, this situation highlights several critical considerations. First, it demonstrates the urgent need for supply chain diversification, particularly in strategic industries. Skydio is currently exploring alternative suppliers in Asia, notably in Taiwan, with U.S. officials actively engaging Asian allies to assist in this transition. The impact extends beyond commercial interests. Skydio has delivered over 1,000 drones to Ukraine for intelligence gathering and reconnaissance, with their latest X-10 model being the first U.S. drone to pass Ukrainian electronic warfare tests. The company had received requests for thousands more units from Kyiv. Moving on to our next story, this development coincides with pending U.S. legislation that would prohibit Americans from using drones manufactured by DJI, the dominant Chinese player in the global commercial drone market. The timing suggests this may be a preemptive response from Beijing to potential U.S. restrictions. For the trade community, this serves as a stark reminder of supply chain vulnerabilities and the increasing use of commercial restrictions as tools in broader geopolitical disputes. We're likely to see this pattern expand beyond defense and drone manufacturing as U.S.-China relations continue to evolve. In a significant ruling, the Court of International Trade has clarified the boundaries of authority between federal agencies regarding import admissibility decisions. Judge Lisa Wang has determined that the Department of Transportation lacks vested authority to make determinations about admitting entries based on federal safety standards compliance. The case emerged from a dispute involving Inspired Ventures' import of rubber tires from China. While Customs and Border Protection initially flagged these entries for potential tariff evasion, the subsequent involvement of DOT's National Highway Traffic Safety Administration led to questions about regulatory compliance and agency jurisdiction. The court's decision establishes that CBP maintains primary authority over admissibility determinations, even when other agencies' safety standards are involved. Judge Wang emphasized that while agencies like the FDA and USDA have explicit congressional authority for entry determinations, DOT does not possess such authority merely through its ability to set safety standards. This ruling has immediate practical implications for trade practitioners. When dealing with products subject to DOT safety standards, it's now clear that CBP remains the primary decision-maker for admissibility. The mere existence of product standards under DOT's jurisdiction doesn't automatically grant them authority over import decisions. Up next, the court drew an important parallel to copyright law cases, noting that while other agencies may govern specific aspects of trade, CBP retains its general admissibility authority. This means that even when CBP consults with other agencies, it maintains its decision-making power over entry determinations. For practitioners handling imports subject to multiple agency requirements, this ruling provides valuable clarity on jurisdictional boundaries and procedural pathways. It reinforces the need to focus primary compliance efforts through CBP while still ensuring adherence to other agencies' substantive requirements. Starting January 2nd, the Treasury Department will implement new outbound investment rules, establishing crucial restrictions on U.S. business activities in China's strategic technology sectors. These regulations specifically target investments in mainland China, Hong Kong, and Macau, focusing on three critical areas: semiconductors, artificial intelligence, and quantum computing. The rules introduce both prohibitions and notification requirements, with particularly detailed parameters for AI-related investments. For instance, investments involving AI systems using computing power exceeding specific thresholds will face strict controls. The regulations set clear computational operation limits, with systems using more than 10 circumflex 25 operations falling under prohibition, while those above 10 circumflex 23 operations require notification. For compliance, Treasury expects companies to conduct reasonable and diligent due diligence before transactions. While the department won't provide a safe harbor provision, it will consider various factors when evaluating compliance efforts, including situations where companies face obstacles in conducting due diligence. The regulations establish a framework for liability, where companies could be held responsible not only for actual knowledge, but also for information they could have discovered through reasonable inquiry. This means firms can't simply ignore red flags or fail to conduct appropriate investigation of their investments. Treasury officials emphasize that these rules are narrowly targeted and include clear thresholds and definitions to help investors navigate the new requirements. The department plans to release additional guidance before implementation, including details on electronic notification procedures and criteria for potential country exemptions. For practitioners, it's crucial to note that these rules complement existing export controls and inbound investment screening measures. While some industry groups pushed for broader coverage, including other countries and sectors, Treasury maintained its focused approach on these three technology areas, viewing them as critical to next-generation military and intelligence applications. The administration has also engaged with international allies, particularly EU members and G7 nations, suggesting possible alignment of similar measures across jurisdictions. This coordination could shape future enforcement patterns and compliance requirements. Major changes are coming to the international traffic in arms regulations defense services definition, raising significant concerns across the defense industry. The State Department's proposed revisions aim to clarify the scope of defense services, but may actually create more complexity and compliance challenges. In our next headline, the proposal notably expands coverage to include consulting services and activities related to intelligence and military assistance, regardless of whether defense articles are involved. This broader interpretation could sweep in previously unregulated commercial activities and companies that haven't traditionally needed ITAR registration. Industry groups warn these changes could severely impact licensing timelines and administrative processes. With commodity jurisdiction requests already taking years in some cases and license reviews often extending beyond 12 months, the expanded definition threatens to overwhelm an already strained system. A particular pain point is the interaction between ITAR and export administration regulations. The new rules could create situations requiring double licensing from both state and commerce departments, especially for services involving ER-controlled items. This overlap risks negating previous commodity jurisdiction determinations and creating confusion about proper compliance procedures. The definition's expansion to consulting services is causing particular anxiety. Standard business activities like marketing presentations or IT support could suddenly require export authorization if they involve foreign military customers, even without sharing controlled technical data. Many industry stakeholders are urging DDTC to explicitly exclude routine commercial engagements from the scope. The satellite and space industry faces unique challenges under these changes. The vague definition of intelligence activities could potentially capture commercial satellite services and geospatial analytics that have historically operated without export licenses. There's a pressing need to distinguish between classified military intelligence and commercial information services. For trade practitioners, these changes signal a need to thoroughly review current compliance programs and potentially expand licensing procedures. Companies should prepare for increased administrative burdens and longer processing times while carefully documenting their due diligence efforts. In a significant update for customs brokers, CBP has finally announced the specific requirements for their new continuing education program. Starting January 1st, brokers must earn 20 continuing education credits by January 31st, 2027, reflecting a prorated requirement for the current triennial period. Looking ahead, the requirement increases to 36 credits for each subsequent 3-year period beginning February 2027. For our concluding piece in this week's episode, CBP is implementing these requirements to ensure brokers maintain current knowledge of evolving customs laws and procedures. To make this transition manageable, the agency will provide a comprehensive list of qualified education opportunities on their website, including free training options from CBP and other government agencies. The National Customs Brokers and Forwarders Association's Educational Institute has been designated as one of 5 entities approved to accredit continuing education courses. This accreditation system extends beyond traditional training to include corporate internal programs and even preparation time for educational presentations. For practicing brokers, these requirements offer flexibility in how credits can be earned. The scope includes third-party training services, internal corporate training programs, and credit for time spent developing educational materials. Brokers can fulfill their requirements entirely through free, online-based training provided by government agencies. This new continuing education framework represents a structured approach to maintaining professional standards in the customs broker community, ensuring practitioners stay current with the complex and evolving landscape of international trade regulations. Thanks for tuning in to International Trade Minute. We hope you found today's episode insightful and useful for your practice. Remember, our podcast is brought to you by Rydell Law Firm, your trusted partner in navigating international trade law. Don't miss our next episode. Subscribe now on Apple Podcasts and Spotify. Stay connected and continue the conversation with us on LinkedIn. Until next time, stay informed and stay ahead.